a Zoom bar. The event will be recorded and it will be available afterwards on YouTube. And there's also a chat function through which you can participate in the conversation with the panelists. So now that we got that out of the way, let me share a couple of words before we go into today's discussion. Because we do have a lot of topics to cover. You will have seen the title of today's discussion. It is focusing on Venezuela's lack of compliance with recommendations issued by the Office of the High Commissioner for Human Rights. And this is a very important and a very specific topic to touch upon and to address. And we hope that today's discussion will provide an overview of what has happened to all the recommendations provided through the UN human rights system to the government over the past years. The discussion comes at a very important point. As you are all aware, in a few days, the High Commissioner, Michelle Bachelet, will present her latest report on Venezuela to the HRC, which will actually focus on a detailed assessment on the implementation of recommendations made in her previous reports. And member states will also have an opportunity to engage in an interactive dialogue, to voice concerns and reflect upon necessary follow-up in the light of a continuously deteriorating humanitarian, human rights, and atrocity crisis. On this occasion, I am very happy to share with all of you that today, and in the context of this event, a group of 22 Venezuelan civil society organizations, including those who are represented on the panel today, are releasing a remarkable, detailed, and comprehensive report with almost 50 pages of data and information on monitoring compliance of the Venezuelan government with OHCHR recommendations since July 2019. And so we hope that this report really serves as a source of information for member states and other stakeholders in addressing lack of compliance with the UN human rights system. The report will be shared in the chat box of this event, and you can also access it on the homepage of Justicia y Verdad and CEPAS. Now, we have an excellent, diverse, and distinguished panel of experts lined up for today. So I want to get right into the conversation. And let me give you first a brief overview of the topics we will be covering. I have my colleagues, Carolina Villadiego, Legal and Policy Advisor for Latin America from the International Commission of Jurists, and Maria Daniela Rivero, an independent human rights consultant from the Centro de Justicia y Paz, CEPAS, who will both be sharing their insights into the situation of domestic justice mechanisms in Venezuela and challenges in accessing international justice. We will then talk about the lack of cooperation and compliance with OHCHR recommendations with Andrea Santa Cruz, lawyer, professor, and director of the Human Rights Center of the Universidad Metropolitana de Caracas, and Calixto Avila, delegate in Europe for Provea, with us. And we're really looking forward to hearing from you. And after that, it will be a great pleasure to give the floor to a human rights activist we all know and admire, Ligia Bolivar, founder and director of Alerta Venezuela, to share with us her work and insights into the work of the Office of the High Commissioner for Human Rights and its impact within Venezuela. So I want to get right into the discussion. It's a great pleasure to hand over to Carolina. Carolina, you worked extensively on issue of lack of independent judiciary within Venezuela. So please do share with us your assessment on domestic justice avenues for Venezuela. Carolina, the floor is yours.
Thank you, Elizabeth. Good afternoon to everyone in Europe, and good morning to everyone in Venezuela and other countries of Latin America. My intervention in this panel will address the situation of the justice system in Venezuela with a view to present factual information on how the judicial independence elements operate in the country to show the complete lack of judicial independence. My presentation is based mainly on the findings of a recent report released last week from the International Commission of Jurists that is named Judges on the Tightrope, and that is available in English and in Spanish in ICJ's website. First, I would like to start by remembering that under international human rights law, the right to be tried by an independent, impartial, and competent tribunal is protected under Article 14 of the International Convention on Civil and Political Rights, as interpreted by the Human Rights Committee, and also that judicial independence standards are established in the UN Basic Principles on the Independence of the Judiciary, which were endorsed by the UN General Assembly. The right to an independent judge is also protected under the American Convention on Human Rights and the jurisprudence of the Inter-American Court of Human Rights. So the core elements of judicial independence require that the judiciary is institutionally independent as a whole, and also that judges are individually independent. There are key elements of judicial independence and judicial impartiality, and as I will address now, they do not exist in practice in Venezuela. So let me address them one by one. First, one key element to judicial independence is that the judiciary is effectively independent from political interference. But the Venezuelan Supreme Court of Justice is under the political control of the Maduro government and the ruling party. And as the Supreme Court of Justice exercises jurisdictional, governance, and judicial management functions over lower courts, the lack of judicial independence of the Supreme Court spread toward lower courts. The political undue control over the Supreme Court has its roots on the processes of selection and appointment of magistrates of the Supreme Court, as these processes have been outside the Constitution and guided by criteria of opportunity and political negotiation. Years ago, the National Assembly unjustifiably increased the number of members of the Supreme Court from 20 to 32 and modified the possibility of appointing magistrates with a simple majority in the Assembly instead of the 2/3 as required by the Constitution. As a consequence, several magistrates were dismissed or pressured to retire from the Supreme Court, and all these situations allowed, in practice, for the executive power and the ruling party to consolidate its political control or undue influence over the Supreme Court by appointing magistrates of their liking. In addition, the Supreme Court has decided cases that favor the government's interest, but that are contrary to the Constitution, such as the ones that authorize the criminal prosecution of 28 members of political opposition parties elected as deputies to the National Assembly in 2015 by requiring that their parliamentary immunity be stripped by the Constitution Assembly, when under the Venezuelan Constitution, only Parliament has such authority. So the Supreme Court of Justice is under the permanent control and undue interference of the executive branch and the ruling party, and this has a concrete effect in the lack of judicial independence of lower courts. Now let me turn to a second key element of judicial independence, which means that there should be established clear procedures to appoint judges, and that these procedures should be based on merit. Now, in Venezuela, since 2003, the competitive public examinations to appoint judges that were regulated under the Constitution have been suspended by the Supreme Court, and since that date, there has not been a call for open and public examination. This suspension had the practical effect of encouraging the prevalence of the appointment of provisional judges, which is contrary to international standards. According with civil society estimates, in 2019, only 15% of judges were tenured, so the rest of judges were provisory. This is the majority of judges in Venezuela. During 2020, according to the Supreme Court, at least 881 judges were appointed provisionally. Thus, there is no process for appointment of judges that is based on merit due to the suspension of public competitions by the Supreme Court, and because most of the judges are right now provisionally and discretionarily appointed by the Supreme Court through its Judicial Commission, there is also no security of tenure, which is another key element of judicial independence. Let me turn now to another key element of judicial independence, which refers to the fact that conditions of suspension and removal of judges comply with due process guarantees. Now, in Venezuela, the Judicial Commission that, as I said before, operates under the Supreme Court's umbrella, has broad powers to appoint and remove provisional judges that are the majority in the country, and also has broad powers to create, modify, and abolish courts. Furthermore, the Supreme Court has ruled that the removal of provisional judges does not require a disciplinary procedure, which is contrary to international standards. Also, there are several weaknesses regarding the disciplinary jurisdiction that was established by the Constitution, because the disciplinary bodies have failed to be implemented, and so disciplinary judges are now in practice directly appointed by the Supreme Court. So this increased the de facto influence and control exerted by the Supreme Court over judges of lower courts. So this process of removal from office of judges do not comply with international standards. Let me turn now to a fourth and key element on judicial impartiality, which is the other guarantee that is part of Article 14. So judicial impartiality is the fact that judges do not allow their rulings to be influenced by personal bias, prejudice, personal interest, or by unduly promoting the interest of one party to the detriment of the other one. Basically, the judges decide their cases based on facts, evidence, and law. Now, there are several breaches to judicial impartiality in Venezuela. For example, judges receive undue pressure and instructions by head judges and presiding judges on how to make certain decisions in their judgments, especially in criminal cases and especially in cases where the government has high interest. Also, there are persistent threats against judges who deviate from the explicit or implicit instructions given by the authorities or their perceived wishes. In addition, the judiciary has been implicated in corrupt practices, such as bribery, asking persons that access to justice to pay money to do the most typical and practical procedures in the country. Also, there are cases of judges who are linked to companies that are contractors to the state. So, as you can see, there are several breaches to judicial impartiality. So, to wrap up, the key elements on judicial independence and judicial impartiality that I have addressed in my presentation are completely absent in Venezuela. That is why there's no judicial independence in the country. So, to conclude, the ICJ considers that it is essential to reestablish and guarantee the independence of the judiciary in Venezuela, which also means restoring the rule of law in the country. Our main recommendations are aimed at urgently depoliticizing the judiciary in general and specifically the Supreme Court of Justice. Also, the ICJ suggests to the international community to publicly call on the Venezuelan authorities to comply with their commitments to upholding international human rights and rule of law, including the duty to guarantee judicial independence. Finally, the ICJ urged the Human Rights Council to maintain a mechanism to address proper accountability for gross human rights violations occurring in the country until judicial independence and prosecutorial independence is restored. Thank you.
Thank you so much, Carolina. That was a really comprehensive and very concerning assessment of the situation of domestic justice avenues in Venezuela. And particularly, I think the recommendations that you mentioned at the end are incredibly useful for participants, in particular delegations who are present here today and who are preparing for the engagement for the interactive dialogue in Geneva. So thank you so much for that, Carolina. I want to hand over immediately to Maria Daniela to complement Carolina's assessment on the perspective of access to justice from an international level, so access to international justice. Maria Daniela, the floor is yours.
I'm sharing a presentation. I don't know if you all see. One second.
I think we had it there for a second and then it disappeared. Oh yeah, I think there it is.
There you go. So I'm gonna talk about access to international justice and the problem of the exhaustion of domestic remedies. As Carolina stated, and we are here summarizing, for over 6 years, Venezuela has been going through a complex humanitarian emergency that affects all people within its territory. In the last 2 years, the decline in the human rights situation in Venezuela has been evident. The government has directly contributed to a deterioration in the quality of life and access to essential public services. It has also actively taken measures to intimidate, criminalize, and persecute dissidents and civil society organizations, and worsening institutional weakness conditions that have allowed them to gain and maintain power. In the face of a multidimensional and complex humanitarian crisis, the international community response continues to be very insufficient. One solution will be to apply the formula of the unwillingness of the state to guarantee the right to judicial protection as an exception to the rule of exhaustion of domestic remedies by international human rights bodies. What is the importance of this formula? First, the international jurisprudence has indicated that applying the principle of complementarity is the foundation of access to international jurisdiction. The exhaustion of domestic remedies must be also understood as an element intended for the benefit of individuals subject to this protection of international human rights bodies. Thus, access to international jurisdiction is intrinsically related to the possibility that domestic mechanisms can comprehensively remedy a human rights violation. As a consequence, the exhaustion of domestic remedies that reasonably are not going to be effective is not required in international law. In almost all countries of the region, it is possible to identify structural situations of lack of independence of the judiciary. However, in some cases, it is possible to recognize specific elements of how this context operates to hinder access to victims of human rights violation to legal remedies. These elements should be considered as an impediment that works even ex ante under one state policy. The formula of lack of willingness, of lack of capacity, has been applied within international law. For example, it's contemplated as an exception to the rule of exhaustion of domestic remedies in the Rome Statute of the International Criminal Court, which established that cases will be admissible when the state is unwilling or unable to investigate any of the crimes. The application of the formula of lack of capacity or disposition of the state should start from a comprehensive analysis of the context that operates to cancel that capacity, the capacity of the state to provide legal resources. It will be applicable insofar it is possible to identify specific elements of that context in the case. In this sense, the determination of international organizations within the framework of monitoring and follow-up mechanism of the human rights situation in Venezuela will be essential to carry out this analysis. It's important to highlight it that the fact that the rule of exhaustion of domestic remedies in both the American Convention and the ICCPR have worded and seemed to favor at least an attempt to exhaust a remedy. But this should not be interpreted in any way that impedes access to international justice. This provision cannot become a protection for the state that rewards its unwillingness to comply with human rights obligations. As stated previously by my colleague, there is a consolidation of the unwillingness of the Venezuelan state to guarantee access to judicial protection. The fact-finding mission highlighted that their investigation revealed interference with the independence of the judiciary, obstruction of the right to fair trial by an independent impartial tribunal, and this is particularly apparent in political sensitive cases. In this case, the fact-finding mission affirmed the judiciary has itself become an instrument of repression, creating accountability imbalance at variance with the principle of equality of arms. The mission documented cases in which members of the judiciary were involved either by act of omission in the perpetration of serious human rights violations. This is especially true in the case of the criminal prosecution of political opponents. One example of this is the persecution, arbitrary detention, and death of Albán Salazar. And it's a consolidation of the unwillingness of the Venezuelan state. Few elements are, for example, the judge and public prosecutor leading the investigation, and Fernando Albán, were also involved in cases of arbitrary judicial persecution of other members of the opposition. The arbitrary detention without showing an arrest warrant, and the retention of Albán for 48 hours. The multiple contradictions in the explanation provided by high-level authorities, as well as the extremely short time lapse between Albán's death and official statement affirming it was a suicide. The multiple irregularities in the investigation, such as the unqualified practitioners who carry out the autopsy, the formal errors in the death certificate, the conflating testimonies of witnesses, and the photography showing wounds and injuries that did not match the conclusion of the death certificate, and the fact that the window where he's supposed to jump only opens 30 degrees. The investigations into Albán's death are inconclusive. The state is unwilling to investigate the crime. And so what is a possible solution for these cases? And it will be, taking into account that the judiciary lack of independence in Venezuela deepens the denial of justice when requiring exhausting internal channels that are neither suitable nor effective. The formula we propose concerning the waiver of the requirement of exhaustion of domestic remedies in Venezuela is decisive that both the international organizations understand that both the structural obstacles that operate to prevent access to justice, as well as this consolidation of the institutional breakdown and the rule of law, informs the admissibility analysis. Why is this? It's because the only mechanism currently available for Venezuelans is the protection of the rights by international jurisdictions. It must be emphasized that the analysis carried out by the past give a detailed account of all the elements that makes impossible for the people in Venezuela to have minimum guarantees of access to justice. Everything mentioned before should be sufficient reasons to analyze compliance with the requirement of exhaustion of domestic remedies in Venezuela from a context in which it's virtually impossible to access domestic remedies. Therefore, it's essential that for the analysis of this requirement in international law of complementarity, human rights bodies take into account the determination that they already have made about the lack of judicial independence in Venezuela and in contention cases and in their mandate to monitor human rights situation. We believe that UN human rights bodies must transcend formalism and fulfill their mandates firmly in the face of delays, excuses, and distractions used by the Venezuelan state to avoid assuming responsibility to protect and guarantee human rights. It has not yet been understood that Venezuela needs a multi-level response. In the face of a government that exhibits no willingness to cooperate and comply with its obligation to protect the population and refuses to implement recommendations aimed at guaranteeing access to justice. We urge the international organizations, including the Human Rights Committee and the Fact-Finding Mission, to understand the principle of complementarity cannot become a protection from the state that rewards its unwillingness to comply with its human rights obligation. To consider both the structural obstacles that operates to prevent access to justice, as well as the consolidation of the institutional breakdown and the rule of law in Venezuela in their admissibility analysis. This is the only way that Venezuelans can have access to international justice. Thanks.
Thank you so much, Maria Daniela, and thanks to both of you for that really detailed assessment of both international and domestic avenues for justice. And I think you both touched upon a couple of really fundamental issues here. And what stuck with me, Maria Daniela, is what you said is the quote that the judiciary has actually become an instrument of oppression. And I think, again, it comes back to the need for international engagement to really center around the discussion on justice for victims. One, I think obviously to ensure legal and political accountability, but also, and this is what I take from both of your presentations as well, is that what we have seen in Venezuela is that the lack of access to justice and the lack of accountability actually does embolden perpetrators to continue systematic violations and abuses in a context of persistent impunity. So thank you so much for your presentations. I want to now change gears a little bit and look at what NGOs have found when monitoring compliance in cooperation with the UN human rights system with regards to the specific violations and abuses that the High Commissioner and the fact-finding mission have reported on. And I want to hand over to Andrea from UNIMED, who will share with us an analysis specifically on extrajudicial executions, arbitrary detentions, and torture. Andrea, please, the floor is yours.
Thank you for this space. The human rights in Venezuela is really worrying for both the national and international communities. We live in a complex humanitarian emergency that has resulted from the absence of the rule of law and the erosion of democratic institutions. Today, we are victims or witnesses of systematic and widespread human rights violations. According to the independent international fact-finding mission on the Bolivarian Republic of Venezuela, FFM, the state committed some of these violations large scale, and that amounts to crimes against humanity. I will talk about extrajudicial execution, arbitrary detention, torture, and cruel, inhuman, and degrading treatment because these crimes have been part of the analysis and investigation of the OHCHR, the Office of the High Commissioner for Human Rights, and fact-finding mission as part of the grave cases in our country. First, I will talk about extrajudicial execution. On July 4th, 2019, Michelle Bachelet, High Commissioner for Human Rights, presented 23 recommendations to the government of Venezuela, 3 of them regarding extrajudicial execution. First, take immediate measures to halt, remedy, and prevent human rights violations, in particular gross violations such as torture and extrajudicial executions. Second, conduct prompt, effective, independent, impartial, and transparent investigation into human rights violations, including killings of indigenous people, and bring perpetrators to justice. Dissolve FAES, the Special Action Forces of the Venezuelan National Police, and establish an impartial and independent national mechanism with the support of the international community to investigate extrajudicial execution during security operation, ensure accountability of perpetrators, and redress for victims. Another recommendation of very important in terms of human rights is ratify the optional protocol to the Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment, and the Convention for the Protection of All Persons from Enforced Disappearances. The fact-finding mission also made recommendations on this matter. Some of these were immediately issue high-level directives within police forces, particularly the PNB and the CICPC, to halt extrajudicial execution and publicly declare that these crimes will be promptly investigated and those responsible punished. Consider establishing a special prosecutorial unit within the Public Prosecutor's Office to investigate crimes of extrajudicial execution by police as well as police cover-ups. Dismantle the FAES, given the high number of extrajudicial executions carried out by these police forces since its creation. I will do my best to summarize such an extraordinarily complex topic since I don't have time. In July 2015, the Venezuela government announced the beginning of the Operation Freedom for the People to fight crime. However, this policy has become a huge source of human rights violation and extrajudicial executions. The Venezuelan NGO COFAVI documented 1,396 cases of extrajudicial execution just in 2015. By 2016, the figure had increased by 70%. COFAVIC has recorded 10,971 possible cases, but only 3,684 occurred between 2017 and 2018. Human Rights Watch also documented that between 2016 and 2019, almost 18,000 people died at the hands of the security forces in Venezuela, allegedly for resisting authority. We also believe that extrajudicial execution have occurred during the manifestation, and it's part of a policy against those who disagree with the government. In September 2020, the fact-finding mission identified two distinctive state policies: a policy to silence and discourage political opposition, including targeting individuals who were perceived as being against the government, and a policy to combat crime, including eliminating individuals perceived as criminals through extrajudicial execution. The country also has been under a state of economic emergency since 2016. And in that context, the government created civil-military security plans. One of these plans was the Plan Zamora, activated in 2017 to repress anti-governmental protests. Recently, in La Vega, an impoverished neighborhood in Caracas, a security operation led by FAES resulted in 24 people killed. Instead of investigating the numerous allegations of human rights violations committed by members of the FAES, the Venezuelan authorities have defended their action. In July 2019, President Maduro stirred long life FAES and expressed his full support for FAES, as documented by Human Rights Watch. The FAES impunity has been an example to other forces, especially the CICPC. The Venezuelan state has not complied with any recommendation from OHCHR or FFM. Regarding torture, the fact-finding mission recommended in September 2020 that the Venezuelan authorities should immediately cease any practice, including torture or cruel, inhuman, and degrading treatment, suspend those members of any state institution while they are being investigated for torture, train medical personnel in the investigation and documentation of physical and psychological torture and other forms of ill treatment, including through sexual and gender-based violence based on the Istanbul Protocol. In the anti-governmental protest of 2014, torture has become a systematic phenomenon. During that year, at least 185 people were subjected to torture. The Committee Against Torture expressed its concern about the high rate of impunity that operates in cases of torture. The committee documented 31,096 denunces made between 2011 and 2014, and that the public ministry only presented accusation in 3% of the cases. In 2014, the CDH-UCAP concluded that the vast amount of torture cases violated the United Nations body of principle for the prosecution of all persons under any form of the detention or imprisonment and the Istanbul Protocol. The execution of acts of torture is not due to accelerate events, but rather to a state policy that follow a chain of command. Torture has traditionally been used on ordinary prisoners, but as political dissent has been criminalized, it has been applied to people detained or deprived of liberty for political reasons. The CDH-UCAP point out that given its systematic nature, this action has become a de facto policy directed at people who disagree or are presumed to disagree with the government, and conclude that its use has a double intention: the intention to punish and the intention through punishment to send a threatening message. It's a similar idea like the fact-finding mission conclude. The government has not complied with any recommendation on the matter, and the use of torture by security force is widespread. Finally, regarding arbitrary detention, OHCHR recommended to release all persons arbitrarily deprived of their liberty and seize and prevent excessive use of force during the demonstration. The number of policy prisoners constantly changing, the revolving door effect, as named by the Penal Forum phenomenon. This phenomenon means that every time someone is released, other people are detained. Doctors United of Venezuela denounced in 2019 the arrest of 11 doctors in various states of country and 45 cases of persecution, threats and intimidation against medical professionals for protesting the crisis in the health system. The Venezuelan Panel Forum has documented the arbitrary detention of more than 15,000 people between January 2014 and May 2019. It is particularly worrying that many of these detentions constituted forced disappearances until the authorities revealed the whereabouts of the people deprived of liberty. Provea and the OBCS record more than 6,000 protests nationwide from January to August 2019. More than 8% were demonstrations for economic, social, cultural, and environmental rights. The response of Venezuelan state to this legitimate and peaceful demonstration has been repression and criminalization. In December 2020, Provea report at least 33 arbitrary detentions, 7 of them women. This unlawful deprivation of liberty occurred in 11 states of the country. The Venezuelan state has not complied with the High Commissioner recommendation. In conclusion, the state doesn't have real compromise to attend to its international obligations. On the contrary, its actions evidence a government commitment to the human rights violation happening in Venezuela. Thank you.
Thank you so much, Andrea, for this overview of ongoing patterns of extrajudicial executions, torture, arbitrary detention. And as you pointed out, these were really some of the elements which were identified by the fact-finding mission to possibly amount to crimes against humanity, among others. There is a clear policy in place. And I think just to link it back to what Carolina Maria Daniela mentioned before, it comes back to the question of accountability and justice, because impunity begets impunity, and only by holding perpetrators to account and signaling that there will be consequences, may you also contribute to somewhat of a prevention aspect and non-recurrence. But the lack thereof, the lack of accountability and the lack of follow-up really does the opposite, as you've highlighted, because these violations and abuses continue to take place in a systematic and in a widespread manner. So thank you so much for that, Andrea. Calixto, you've been working unabatedly for Provea in Geneva, in Brussels, in The Hague. Please tell us more about the situation of economic, social, and cultural rights and vulnerable groups in Venezuela. The floor is yours, Calixto.
Thank you very much, Elizabeth, for this opportunity. First of all, I would like to say hello to everybody, ladies and gentlemen. In its report on the human rights situation in Venezuela dated July 4th, 2019, the Venezuelan state was requested by the High Commissioner to regularly publish comprehensive health and nutrition data and to allocate the maximum possible quantity of available resources to the progressive realization of economic and social rights in a transparent and accountable manner that allows for the evaluation of expenses. But despite those recommendations, there are no institutions that regularly publish disaggregated data, since all the data collected were obtained from civil society organizations working in the field. This data confirms that we are facing a continuous and severe deterioration of human rights in Venezuela. This situation is characterized by a profound undermining of the rule of law and the disintegration of the democratic institutions. The country is facing a complex humanitarian emergency on a national scale and multidimensional character, with severe impacts on the massive deprivation of minimum adequate living standards for the majority of the population. In 2020, the index of wage earners in Venezuela, including both the public and private sectors, fell to 46%, while self-employment grew proportionally. The real purchasing power of the monthly minimum wage covered only 0.5% of the basic food basket. Venezuela currently occupies the last place among minimum wage in Latin America. Between 2014 and 2020, official figures assumed that 2,906,256 homes were built. However, an investigation by Provea estimates that only 123,552 new homes would have been built in the country. The collapse of essential services prevent most Venezuelan households to safely meeting the standards of protection against COVID-19. According to the ENCOVI, the main academic independent survey, 70.12% of households had a deficit in providing public service nationally. In 2020, demands related to adequate housing and essential service were the leading cause of protest, while demands for labor rights occupied the second high reason. Concerning the indigenous population rights, the lack of demarcation of indigenous territories, violation of the right to prior consultation, and extractivism on indigenous territories persisted. The deficiency of supplies and medical personnel in outpatient clinics in different indigenous communities continues to be alarming. The United Nations High Commissioner for Refugees reported that 5,020 Venezuelan indigenous were registered in Brazil, 60% of them members of the Warao ethnic group. At this time, there is not yet a national vaccination plan against COVID-19. The COVID-19 pandemic accentuates the pressure on water, sanitation, and hygiene services. According to the UNESCO, Venezuela is ranked 4th among the Latin American and Caribbean nations, which register the most significant inequality in access to water between the richest and the poorest sector in the population. On the other hand, Nicolás Maduro created the Special Military Economic Zone for Forestry Development, with extensive power to administrate and exploit territories until now protected due to their environmental importance. The Maduro regime's mega-extractivist plan, the Arco Minero del Orinoco, continues to advance, generating negative impact upon society and the environment. Concerning the right to social security, in September 2020, the Venezuelan Institute of Social Security indicated that there were 4,960,522 pensioners. In December, the pension was the equivalent to $1 per month, according to the official exchange rates. Venezuelan pensioners living abroad have not received their pensions over 4 years. Concerning the right to food, severe malnutrition in children under 5 years old is in vulnerable communities was 12% last year, exceeding the crisis limits according to the humanitarian standards. Food consumption deteriorates in quantity and quality, affecting families living in poverty that cannot consume the minimum amount of calories for subsistence. The average amount of cash transfer assigned by the government through the Patria system was the equivalent of $3 to $3 American. Last year, the purchasing power of households that earn the minimum wage went from 1.7% in January to 0.5% in December. Once again, the ministries of agriculture did not present their memory and account to the National Assembly in 2020. According to the official press releases published in that period, only 6,428 hectares were handed over to peasants. The policy of excluding producers who are not loyal to the government continues. Agricultural products continue to be imported to detriment of national production. Lack of gasoline and diesel is a factor that prevents the development of agricultural production and its commercialization. Excellencies, ladies and gentlemen, although unilateral economical sanctions affect the worsening of the situation in Venezuela, this doesn't exclude the responsibility of the national government at the origin of the existing situation of the complex humanitarian emergency. This humanitarian emergency predated that sanctions. Years of corruption with impunity and mismanagement led the country to the current situation. I thank you very much, Elizabeth.
Thank you so much, Calixto, for your assessment. And you mentioned a very important point there, which is sanctions. So perhaps we will have an opportunity also to get back to that later in the Q&A session. But thanks to all of you. I think that your analysis on so many different and at the same time interlinked issues and areas, it really allowed us to have a holistic assessment of the crisis. But most importantly, of the lack of the government's willingness to really utilize the UN human rights system, which again provided recommendations for action on all these areas, as you've highlighted, to implement meaningful measures and reforms. And I think as we head into another year and into another council session of oral updates, reports, interactive dialogues at the Human Rights Council, I think this is a message that is essential, that despite engagement and recommendations, there's no genuine follow-up. To the contrary, we see the crisis continues to deteriorate from a human rights, humanitarian perspective, and it's important for states also to give visibility to that. Just a quick reminder that in the chat box, we have the link to the report from the 22 Venezuelan organizations on compliance and cooperation. And we also, I think, have the link to the report from ICJ, which Carolina mentioned. And another reminder, if you do have any questions, please drop them in the chat box so that we can address them later. But first, I want to hand over to Ligia. Ligia, your organization, Alerta Venezuela, provides a very in-depth analysis, not only on the multidimensional crisis within Venezuela, but also, and importantly, on how on an international, multilateral, and regional level, what the response looks like and how effective that is. So please, Ligia, tell us a bit more about your assessment and your analysis on that. The floor is yours.
Thanks, Elizabeth. Thanks to the organizers of this side event for giving us the opportunity to share some reflection this morning or afternoon, depending on where you are. I think that to understand the recent position of the Office of the High Commissioner on Venezuela, it is necessary to refresh some facts about the context in which the office is working in Venezuela. Alerta Venezuela carried out a comparative study for four country experiences to draw lessons and learnings for the case of Venezuela. The case we analyzed were Cambodia, Colombia, Guatemala, and Tunisia. In addition to reviewing documents and conducting interviews with the human rights defenders and current and former officials from these offices, we also conducted interviews with human rights defenders in Venezuela after the first 6 months of the so-called presence of the Office of the High Commissioner in Caracas, which is now 2 years old. you might find the link to the report both in English and Spanish soon in your in the chat. So part of my presentation will be based on the findings of this study, but we will not be only related to that. The first thing that strikes about the office presence in Venezuela is secrecy. There were confidential negotiations, no civil society organization participation, no participation of interested states. The letter of understanding is unknown, is a secret, and we only receive oral information about the content of this letter. So secrecy results in lack of sense of ownership by civil society organizations and interested governments that puts the presence in Venezuela in a very precarious position, and that makes it susceptible to pressure by Maduro government. Of course, the pressure have always existed, but it's more difficult to deal with it in these circumstances. At the beginning, presence of the office in the country was functional to the government because they can say we are cooperating with UN human rights system, and in fact, that's what they used to say. But more recently, Maduro government is using the office to presence as a bargaining chip to put pressure. If you don't behave, they say you must go. That's the last thing they said recently. But in addition to being more difficult to speak out loud and clear, the direction given by the High Commissioner is worrying. Since the office arrived in Venezuela, the High Commissioner has lowered her tone on the country. Bachelet lobbied, for example, against the resolution to create the fact-finding mission, and there's a minimum cooperation, not to say there is no cooperation at all with the fact-finding mission, with the argument that the mission is independent, while in other countries and in other times, there always has been close cooperation between the office and other initiatives such as the fact-finding mission, missions of inquire, special envoys, etc. This rigid position of non-interaction with other components of the UN human rights protection system is also observed in the face of special procedures, for example. In the name of independence, again, we are not working in cooperation with the rapporteurs to the point that the visit of the rapporteur on coercive measures, that was the last visit we had in the country, was organized through the wrestling coordinator's office and not through the presence in Caracas of the High Commissioner office. When one of the most valued points in this Alerta Venezuela study that I mentioned at the beginning was precisely the close cooperation of country offices with the special procedures. The Venezuelan team has been dismantled. That's another worrying thing. We understand there is always staff rotation, but the whole team in less than 1 year seems unwise, to say the least. The High Commissioner has recognized supposed advances and progresses in the country, which are not such. For example, she mentioned that management of COVID in prison was positive. And in the same paragraph, she mentioned the government efforts to ensure biosecurity measures in prison are as a good point, but it also says that there is no water in prisons. And we all know what hygiene means in preventing COVID, and it's based on water. So if you have contradictions in the same paragraph, it puts the office in an awkward position, to say the least. He also mentioned that applaud the fact that political prisoners had access to Zoom, which is not true. The government effort to welcome returnees was also recognized. When we sent a report, and when I say the in this case, we is the Human Rights Center at the Catholic University in Venezuela. We sent a report to Caracas, Geneva, and Panama focal points of the office on criminalization of returnees who were classified as biological weapons and as bioterrorists, and were confined in inhuman conditions in the country. Another example is that after the false parliamentary elections in December last year, the High Commissioner acknowledged that there was no violence during the event, as if it were no violence before the strongman of the ruling party threatening the population, saying that if they don't vote, they will not eat or will not have bags of food in a country subjected to hunger and malnutrition, as Caristo recently said. In addition to that, there are two very serious facts about which there has been no pronouncement, no position taken by the High Commissioner's office. There is an armed conflict on the border between Colombia and Venezuela and Alto Apure, with more than 60,000 refugees fleeing to Colombia from Venezuela. No words about it. On an administrative ruling that obligates NGOs to register in an anti-terrorist registration, and that might be the end of civil society organizations. There has not been any word from the High Commissioner's office. Another event on which there has been silence, and there was a belated reaction, was the arrest of 5 human rights defenders and humanitarian workers of the organization called Azul Positivo. It was the first time that we had human rights defenders arbitrarily detained and put on trial, and they're still on trial. They clearly fit into the profile of people affected by mutilation for cooperating with UN system, because they were working closely in cooperation with UNAIDS in the country and with other agencies. And the office took weeks to react. After the last oral intervention of the High Commissioner, Venezuela not only rejected her assertions, as always, but also threatened to reconsider the presence of the office in the country. The outcome of that threat has been that technical assistance is now suspended. There are no visits to prisons or to other establishment places. The team in Caracas only transmit information to Geneva. Geneva asks that we communicate to Caracas, but Caracas doesn't make any decisions. And so they have become messengers, but very expensive messengers. They do good tracking on detainees, improving conditions of individual political prisoners, for example, but that is something that ICRC can do. So it's very difficult to understand now the role of the presence in Caracas. And we are concerned about the risk that in the next update before the Council, the High Commissioner present as achievements some facts that are not such, like to applaud, as she already did, the announcements of a police reform that nobody knows what is it about. So there's also the risk that Venezuela will exert more pressure, although perhaps the political cost of removing the presence is too high, but they can use pressure as a mechanism to ensure that there is no a voice on what is happening in Venezuela. As Alerta Venezuela saying in its report, we do not need an office in Venezuela, but we need an office for Venezuela. And that is why we propose 7 points, and that's, I will finish with that, a 7-point program to make that happen. First, participation of the civil society and international community in the process of establishing the office, and of course the development of it. Second, balanced mandate between aspects of promotion and protection. Third, complete autonomy and independence of the office. Fourth, sufficient funding to ensure a robust team with a high-profile leadership, including a senior representative. unrestricted access to the entire territory, both for visit and for the establishment of offices across the country. Security guarantees for the equipment, facilities, and people to access the office. And finally, consideration of the office as a non-exclusive option of other international supervision mechanisms of the UN system. Negotiations cannot remain secret or with no participation from civil society organizations and the states. This is a message that must be transmitted by all means from now until September, when the new renewal of the mandate is expected. Thank you.
Thank you so much, Ligia. You mentioned the case of Azul Positivo, which is something I'd love to come back to you in the Q&A session as well, to talk a little bit more about the persecution specifically of civil society actors in Venezuela. But I want to thank you first, all of you. I think this was such a substantive conversation. And again, it was really meant for delegations and member states as they are preparing for their participation in the interactive dialogue, as we're moving also towards September, as a source of information on what is the situation in Venezuela today and what has happened with the vast, concrete, and very action-oriented recommendations that the government has received over the years. For me, listening to all of you, I think that my main takeaway from this conversation and from your interventions is that oftentimes in Geneva, when we face situations of human rights crisis and atrocity crisis, the Human Rights Council does respond by adopting resolutions which request the High Commissioner, special procedures, fact-finding missions, investigative bodies to report on the situation and to provide recommendations. But this conversation today, I think it is an important reminder that such action and such response, by the Council, it's really the beginning and not the end, because there can be as many recommendations, reports, monitoring as you want. But what matters is really to see if there is follow-up, if the government takes these recommendations serious and is genuinely committed to implementing them. And that's really the starting point, and that's really where we are right now. And this is also where the international community, the human rights system, member states and others need to come in and see, is there progress or not? And if there's no progress, what can we do about it? What should we do about it? So I think if there's one thing to stress, specifically with delegations who are present here today, is that the upcoming dialogue really does provide a very important opportunity to address the lack of compliance and cooperation, which unfortunately, as we've heard today from all the panelists, it is a clear indicator that the human rights crisis, the atrocity crisis, the humanitarian crisis is likely to further deteriorate rather than improve. And giving recommendations is not enough. All of us need to look whether something is done with them. And this is again where the report of your organization comes in. And I do encourage everyone to read the report and to use it as a source of information, because it is filled with data and analysis on compliance with various UN bodies. I've mentioned it will be available on the CEPA's website later today, or actually as of now, it's in the chat box as well. And you can access it in English and in Spanish. So thanks to all of you. We have about 10 minutes for questions. I don't see any questions so far in the chat box, but I'm also moderating on Zoom for the first time, so I may be missing something. But until we have questions coming in, I actually wanted to get back to you with a question. And I know Andrea has to leave very soon, but I want to take this opportunity to ask you specifically about the issue of increasing persecution and harassment and restrictions on civil society organizations in Venezuela. Can you all tell us a bit more about what is the current situation within Venezuela for you, for your work, and what do you expect from states, to actively support civic space and to speak out loudly to defend human rights in Venezuela? I don't know who would like to start. I don't know if Andrea, if you want to start. I know you're in Caracas right now. Calixto, Ligia.
Yes, thank you, Elizabeth. Well, in this moment, I think the situation for defenders is really dangerous And maybe the problem is the grave crisis of human rights and all of things we talk in this moment about our situation, and the compromise or the committed from the state not to comply or the compromise to attend this international obligation. On the other hand, the government commitment to the human rights violation happening in Venezuela. And we, in this moment, we, the defenders, we are part of the enemies, internal enemies for the government. And yes, the problem is deeper or deeply in this moment, and we need to the international community understand the worrying situation or the horrible situation in our country and do more for us. I think this is a brief, important recording or remember to the international community all the time, because the crisis in our country have a lot of time, and maybe they believe is, well, now is easier than before, but no, the reality is in this moment the situation is more complicated and is really complex, and we need more help in this moment. Thank you.
Thank you so much, Andrea, for that and for that important reminder, especially for states also who are here today, to really speak up and to actively support and show solidarity. Not only show solidarity, but actively support the work of civil society in Venezuela. Calixto, I know that Provea and members of Provea have been subject to persecution, harassment, threats many times, a lot of them publicly. I don't know if there's something you would like to share on this question specifically as well.
Yes, I think that we have been, all human rights in Venezuela are really in danger. I think this is something that is happening not only from, there is a legal, a juridic strategy to criminalize human rights in Venezuela, and that's important to underline. But at the same time, I think it's very important to know that the Inter-American system is already protecting human rights defenders in Venezuela. They are covered by the specific measures of protection from the Inter-American system. But also at the level of the United Nations, I have to underline also the mechanism of the in charge of the adjoint secretary of the United Nations, because it's a mechanism on reprisals. I think you can say reprisals, sorry, but it's, I think it's active in Venezuela. We have been included, several human rights defenders have been included for years in this report that is presented in September. And I have to underline that in last year, the government even attacked the secretariat, the adjoint secretary, because of her report. So it's very important that the mission in Geneva support this report, who will be presented now in September, and we are really waiting for this report, because it could present the situation that we are facing now in Venezuela. And I expect also that the case of Azul Positivo would be included this year as one important case, specifically because the core from this mechanism was about the people facing the COVID pandemic. And the case of Azul Positivo is one of the cases people working for the population on this topic. Thank you, Elizabeth.
Thank you so much, Calixto. And I actually noticed we had 2 questions coming in from the chat box, which is great. I know we're running a bit out of time, but maybe we can address them both quickly. The first one is, could cooperation with UN system agencies be included in a possible negotiation for sanctions relief? And the second question is, what are your expectations for the High Commissioner's report on July 5th, and what further action can the Human Rights Council take? I don't know if all of you would like to respond to both questions or pick one, but I'll just open the floor and perhaps we can go in the reverse order then we spoke. So I'll start with Ligia and Calixto, Andrea, Maria Daniela, and then Carolina. Thank you.
Thanks, Elizabeth. I'm going to refer to both questions very quickly. What do we expect from the report? The truth. I mean, that's all I can say. Grave human rights violations are taking place in Venezuela, and we cannot accept, that the High Commissioner stress basically focus on applauding the country on dubious advancements and progresses, which is what she has done in the last few years or months. So we want the truth, and we want a strong voice, not only from the High Commissioner, but also from the countries in the Human Rights Council to ensure that Venezuela start at last to fulfill its international obligations. This is nothing new, but it's a shame that that position is being applauded by the office, which should take a position precisely on the opposite direction, which is the protection of the victims. So that's one thing. And with regard to the other question, I don't see. Probably I misunderstood the intention of the question, but I don't see how there is any link between the cooperation with UN system agencies and negotiation on sanctions, because sanctions are not related to the cooperation with the international system or with humanitarian agencies. And sanctions are not related to that. So I don't know if I misunderstood the question, but in that aspect, I would say there is no relation between both. Thanks.
Thank you so much, Ligia. Calixto, do you want to go next?
Yes, I completely agree with Ligia. There is no link with the sanctions that are part of international policy from specific states or even the European Union, who has sanctions on Venezuela, and it's a completely different forum. It's not the United Nations are not imposing sanctions as part of their frame of their international frame. So I think there is no link almost on the negotiation of the accomplishment with the recommendation from the High Commissioner. So I completely agree with Ligia on this point. Thank you.
Thank you very much, Calixto, and I'll head over to Andrea.
Thank you. Well, I agree with Calixto and Ligia. I think our expectation about the new report from the High Commissioner is she or the office must be the truth. They need to say the truth loud and clear, and this is so important to us in our country, for us like defender or as defender, and principally for the victims, and that is important. The other question, I agree with Calixto. I think about the negotiation, we don't have any tools to talk about that. Thank you.
Thanks a lot, Andrea. Maria Daniela?
Yeah, I would say that the complementarity principle is very important for the fact-finding to understand and the Human Rights Council to understand that it cannot serve as an excuse for the state. not to do something. I think that the ICC also understand that the state have the first step to remedy the human rights violation, but in this case, the unwillingness of the state have to take into account for the, for the next report, but also as a recommendation of all UN human rights bodies to understand that asking human rights organizations, asking victims to exhaust local remedies, it's not possible in Venezuela. And that could be one of the actions that the Human Rights Council can take. Impeding the access to international human rights systems, that is the only access that Venezuelans have, using the excuse as a complementarity principle, I think it's not fair for the protection and the guaranteeing of human rights in Venezuela. So that will be the answer to the second question.
Thank you so much, Maria Daniela, and Caro, I hand over to you for the questions as well.
Thank you. I agree with my colleagues in the panel. I also think we expect the High Commissioner to elaborate on the lack of compliance, specific lack of compliance of the Venezuelan authorities on her previous recommendations. I think that's what we are also expecting. And that will be very important for the Human Rights Council. It will be very important for victims and all persons in Venezuela. And it will be important for an overview on the avenues for real accountability for serious human rights violations in Venezuela.
Thanks, Caro. And we're unfortunately already way over time. So I know we have a couple more questions in the chat box, and I do apologize we can't address them. But again, this recording will be available afterwards on YouTube. And please do engage with participants after the event as well, if you do have any questions that weren't addressed here. I want to thank you all so much for this conversation. It was so substantive and so important to have, in particular ahead of the report that is coming out and the interactive dialogue. So many thanks to all of you. And again, the links to the reports are in the chat box. Please do check them out, everyone, and have a look. Many of them are available both in English and Spanish. Many thanks for participating and for listening, and I hope to see you all again very soon. Thank you.
Thank you very much.
Thank you very much.
Thanks. Bye.